Ready. Play.
Well, I'm pleased to be joined rather spontaneously by Dan Kaplan. In fact, so spontaneously, I hope I'm saying your name right.
Kaplan, you're awfully close.
All right, Kaplan, Dan Kaplan. Thanks, Dan. Dan, the reason why, of course, I've reached out to you in this spontaneous moment is because we've had the confirmation in the last half an hour about the PTPA action adding the slams to the lawsuit. Now, this is something you wrote about actually over the weekend, so probably took me by a bit more surprise than it took you. What does this mean for the case going forward?
Well, it means there's going to be a lot more legal lawyer hours racked up. Each of the four slams now have to respond to this. They're going to file their motions to dismiss. There's going to be a briefing schedule set by the judge. I should point out the ATP and WTA, who are currently the only entities being sued by the PTPA, and I think it's 12 or 13 named players. They're objecting to the addition of the slams to an amended complaint.
Okay.
They're not necessarily against it. They want to see their motions to dismiss that process carried out before the complaint is amended. My guess is the judge, who's been pretty sympathetic to the player case, will allow them to amend the complaint, and the slams will have to answer the charges.
Why have they added the slams now and not before, do you think?
Well, one thing, when the case was first filed in March, almost everyone who knew anything about tennis said, how can you allege an antitrust case against anyone in professional tennis and not include the Grand Slams? The Grand Slams, represent probably 75 to 80% of the revenue in tennis. And if you ask the PTPA lawyers, they basically said they were going to get around to it. And they did start to go in that direction. And then they reached an agreement in late June that they would grant a 90-day window to the slams to negotiate with them. That 90-day window ended today. So that's why over the weekend, I was able to say very confidently that the slams were going to be added as defendants. Now, they technically have not been added as defendants. What was filed today was a request by the PTPA lawyers to add them as defendants and to file an amended complaint. They did file an amended complaint as an exhibit, but it's not formally filed. But it does show you what they want to charge the slams with.
Okay. I mean, this might also come as a surprise to some who felt that the case was moving in a direction, albeit a very slow one, to, let's say, the fires had been dampened a bit over the last 6 months. And yet this seems to be a sort of increase regarding the friction between the two sides, if you like, or additional sides as it is in this case.
There's any sense that the fires have been dampened. There's no lack of enthusiasm from the PTPA side. These cases move very slowly in American courts. I'm not sure what they're like overseas, but an antitrust case can take 4, 5, 6 years to wend its way through the courts. So we haven't even reached what's called the motion to dismiss stage. When a case is filed, a party that's sued can file a motion to dismiss. Each side has to file briefs on that, then counter briefs. That process can take 6 months to a year. And then there's a hearing held on the motion to dismiss. And if the judge does not dismiss the case, it then moves into discovery, where each side gets to go through emails and documents and depose key personnel. And that process can take over a year. And then there's what's called the summary judgment phase, which is like motion to dismiss, except with the advantage of having discovery done. And that can take another 6 months. And if it survives summary judgment, then you go into preparing for the trial. And so it's a lot. It may seem like not much has happened, and perhaps that's true, but there's nothing unusual about this in American jurisprudence.
Do you think, I mean, it's a lot of guesswork and reading between the lines, and maybe you can't just answer this question, but I have to pose it. Do you think we'll get to that stage where we are going to a trial, or do you think eventually there'll be some movement from both sides on this?
Well, I hesitate to predict. I mean, there was a case in 2009 in which the ATP was sued by the Hamburg, Germany tournament because the ATP's new schedule had demoted Hamburg from a 1,000 to a 500, and most people thought that would settle, and it didn't. It actually went to trial and went to a jury verdict. The ATP won that case, and that's one of the reasons Hamburg is now a 500 event, not a 1,000. I think most people see the players' case. A lot of people think it's a weak case, but they did draw a judge in the Southern District who seems to be very favorable to their kinds of arguments. It's a little off the beaten path of this discussion, but she's the same judge that there was a case in which Fubo sued Walt Disney, Fox, and Warner Brothers Discovery to prevent those three companies from launching a sports app. And the case we've seen is very weak, but the judge sided with Fubo repeatedly, and they eventually settled the case. So I think the players lucked out on the judge they drew. Now, of course, ultimately, all of this can get appealed to a second level of court system in the U.S. But for the time being, the players have an advantage in the judge, and that could lead the parties to settle.
I see that you have a couple of interesting followers on your social media, on X in particular anyway. I see the PTPA have followed you, and I see the WTA have also followed you. Now, I don't know how long they've been following you, or has it been the last few months because of you following these cases in particular?
Well, I used to cover tennis, the business of tennis, extensively when I was at Sports Business Journal from 1998 until I left Sports Business Journal in 2019. So I was probably the only guy covering the business of tennis at that time. So it was an actual beat of mine. So the PTPA wasn't around then, but the WTA was probably following me from way back then.
Interesting, Dan, that you mentioned that, because given that you've followed the business of tennis, at least, you go back quite a long way with it. I'm also somebody who's been involved in tennis a lot less time than you have, but let's say just over 3 years. And when I'm reading some of the PTPA action, I'm seeing certain things that ring true in terms of, and ring true is about as close as I can get to it, just in terms of some of the frustrations that I have had in dealing with some of these very, well, I'm going to use the word, you don't have to, but I'm going to say close to authoritarian manners in which the way they kind of manage the sport. And we have found that to our frustration, I would say, talking tennis. Does any of it ring true to you in terms of some of the ways that you've seen the way the business of the sport is run?
There's no doubt the players have a raw deal. The players don't get paid enough, especially from the slams. They're getting about 10 to 15% of revenues. And it drives me crazy whenever one of these slams, like in the weeks before the slam, announces their prize money is increased 8% to 15
million. Drives me crazy too.
And the media breathlessly prints that, and they don't print what percentage of revenue that is. And the U.S. Open breathlessly says we awarded $70-80 million in revenue. Well, that's 15% of your in prize money, but that's 15% of your revenue. That's peanuts compared to most sports leagues. The NFL, it's 48-49%. The NBA, it's 50%. English Premier League is like 40-45%. It's I don't want to call it a crime, but it's outrageous what the players are paid. And one of the things that's pointed out in the amended complaint that was filed as an exhibit tonight is that there are these rules on the ATP and WTA tours that the prize money of their tournaments can't exceed the Grand Slams. And so what the players are arguing is that effectively acts as a cap on there's no competition with the Grand Slams to raise prize money. Larry Ellison, who owns the BNP Paribas Open, he could easily have prize money the equivalent of a slam, but he's not allowed to. And so that does seem to be a restraint of trade and a restraint on player services.
We have also, on this exact point, I'm glad you mentioned Larry Ellison in that case, or that example, because I speak to tournaments, I speak to tournament directors, not necessarily the big ones such as Indian Wells, but let's say some of the others just a little further down the food chain. And they want more media coverage, more new media coverage, such as ourselves, for example. But they're saying that the ATP and the WTA are trying to keep a lid on that. Now, I don't know why, and I can't join all the dots to it. But there must be a reason behind it. This is what I mean between a schism, or what I'm going to explain just quickly to you, is where I feel there's a schism between the tournaments and those running the sport. Because I think if you could give a little bit more autonomy to the tournaments, I think that they would grow the sport arguably better and quicker than those actually running the sport. But I don't quite understand why. That's what I can't quite join the dots on, Dan.
Well, there in any sports league or sports circuit, there's going to be tension. I mean, the NFL, there's tension between 345 Park Avenue, the headquarters of the NFL, and the 32 teams. The same in Major League Baseball. I mean, you've probably heard the name Jerry Jones, and he became famous for rebelling against the restrictions of the league office. So it's not unusual that there'd be a governing body that oversees multiple entities, in this case, tournaments that want to do things differently. And it's a one size fits all approach doesn't often work with some of those tournaments. And Larry Ellison's the perfect example. I mean, I'm sure he would like to offer 50, 60 million in prize money, make it the legitimately the fifth Grand Slam.
What do you think might happen next? Is there anything? I mean, you do from time to time, you follow this pretty closely. I mean, you've been in the rooms, right, when some of these hearings have been occurring. Am I right?
Yeah, there was a hearing. What happened was right after the case was filed, the ATP circulated a letter trying to get players to sign it, saying they would that they oppose this litigation, and the players that filed the lawsuit moved to enjoin the ATP from pressuring players to do that. And so there was a hearing on this, and I was in the hearing. I think it was a 2-day hearing, and the judge ultimately essentially ruled in the players' favor that the ATP had impermissibly put pressure on players not to join the lawsuit. Now, not many players have joined the lawsuit since. So, that ruling was another reason I'm pretty confident that players lucked out with this judge.
How well do you think the media are covering this? Because again, there's a relationship, I think, a much closer relationship. I'm a journalist of more than 20 years. I've covered other sports as well as tennis, but I also do a lot of news journalism as well, and all the other stuff. I find the relationship between the media and the tennis authorities a lot more cozy, a lot more warm, a lot more dependent on each other, let's say, than in other sports, where I find that there's sometimes three or four different entities in football, for example, or soccer, as you may well call it. You know, you'll also have a players' association, which is independent from the body that is running either the Premier League or FIFA or so on. And there does seem to be a little bit less, as I say, of a warmth between these entities and the media. And so the media, you know, let's say, are a little bit more aggressive in their questioning and a little bit less cozy with the powers that be. What do you think about the way the media's been covering this PTPA action?
I think the overall reaction was negative. That I agree with you. I mean, the podcasts I listened to, they were ripping apart the complaint. Just, you know, and look, there were problems. Look, there were clearly problems with the complaint. But the overall thrust of the complaint is not inaccurate in that the players don't have the rights they probably should have. Now, they can't have a union because they're not organized that way. They're not employees of the tournaments or of the tours. But you know, the PTPA is out there trying, and they sort of filed this lawsuit as a last resort. And but from what, I mean, I heard, I mean, Andy Roddick went after it on his podcast, and the tennis podcast, which I'm a big fan of. They dissected it left, right, and center. And again, they made some valid points about errors in the complaint, and those have largely been fixed. But I think it betrayed sort of an I don't know, an ignorance of how this process works. A lot of times, everything gets thrown against the wall in the initial complaint, and then through dissection and introspection, things get pulled out and it gets cleaned up, and that's what's happening in this case. But we'll see. But the coziness you say in tennis, it exists in other, at least in the U.S., it exists in other sports. The NFL is, I mean, the media is often, with some exceptions, quite obedient.
Okay. In soccer, I think less so. I mean, there's certainly a relationship between the players and journalists in soccer, because the journalists, of course, want to get the stories, they want to ghostwrite the autobiographies, and there's all sorts of things at play there. But I think that certainly in soccer, they're not afraid to go after the authorities, as we've seen with FIFA and the British media in particular. One final thing, though, Daniel, before I do let you go, is sort of just to row back slightly in terms of the case. And I mean, is there anything that you could foresee in the next sort of, 6 to 12 months happening, or even just the next few weeks?
Well, the parties want a hearing in the case to go over the issues that are outstanding right now. The motions to dismiss, this new request to file an amended complaint to add the 4 slams as defendants. So I'm hoping, as a journalist, sometime in the next month there might be a hearing scheduled, and I'll get inside the courtroom again as I was for the previous hearing. And usually you get good news stories out of those experiences. But again, to go back to my earlier point, it's a slow process. If there's a hearing on motion to dismiss, the judge will take everything under advisement, and she'll probably rule 2-3 months down the road. And if she doesn't dismiss the case, then again, it's a long process of discovery, summary judgment motions, and then there's if it gets to pretrial, there's a whole process they got to go through there.
Well, we'll have to be patient, and we'll have to play the long game and see how this. We're still very much in the first set, and I guess we're on serve right now.
Well, I guess if we're talking best of 3 or best of 5, we'd have to specify that.
Okay, yeah, good point. Let's say best of 5, but I think we're still in the first set, aren't we, Daniel?
Unless the case gets dismissed, yes, we're still late in the first set, at least.
Yeah, towards perhaps a first set tiebreak. Daniel, thanks very much for joining me, and make sure to give Daniel a follow on X anyway at Kaplan Sports Biz. I will also spell that out and get that, all your stuff, including your Substack, which if I'd read, Daniel, it would have eased up. I think we had like 5 or 6 emails quickly back and forth as to what I wanted and what you were in a position to say. And it was like, I then saw, of course, because you sent me the link for the Substack piece that you wrote over the weekend, which actually would have preempted this news by a day or two. So we'll also add that to the description. But yeah, big thanks for joining me, Daniel.
Thank you for having me.
If you enjoyed this video, make sure you hit that like button. Don't forget to subscribe and click that notification bell so you don't miss out on all things tennis.